Okay, I can see the numbers are slowing down now. So on the assumption that most of the people who are attending are now with us, welcome to this afternoon's seminar. My name's Jamie Burton. I'm head of the Community Care and Health team here at Doughty Street. That's the team that's putting on this particular seminar on children in unregulated accommodation. It's been a particularly controversial issue, one which concerns children sometimes with multiple needs, ones with perhaps heightened vulnerabilities, who are finding themselves in accommodation which is entirely unregulated and in circumstances where, at least some of the time, it ought to be regulated, and therefore the placement is effectively being run unlawfully. As I say, it's been a controversial issue. It's been picked up by mainstream media, including BBC's Newsnight, and I think we'll be hearing a bit more about their investigation during the talks later on this afternoon. It's also been the subject of a very recent government consultation, and it's also been the subject of an excellent report by Just for Kids Law called Not in Care, Not Counted, which deals with one particular aspect of this controversial issue. I'm delighted to say that we have two speakers today from Just for Kids Law. We have Kadie Murphy, who's the Policy Officer for Housing and Social Care. Kadie used to work in the Children's Society and has also worked in Parliament for Kate Green MP, working on similar related issues. And Mittal Rafatha, who's Head of Education and Community Care for Just for Kids Law and is a solicitor who's been working on cases, again, relating to this very topic and therefore has first-hand experience of some of the problems that are being experienced by these vulnerable children. Just a few pieces of housekeeping before I hand over to our first speaker. The first is we will be taking Q&A on today's session, but we'll be dealing with them all through the Q&A written function at the bottom of your screen. If you look down at the bottom, you'll see a Q&A tab. And if you wouldn't mind, please writing your questions in there. We'll deal with all of them after we've heard from all of our speakers this morning. I should also point out that this afternoon's seminar is being recorded, and both the recording and the slides will be available on the Doughty Street website, not immediately after the seminar finishes, but certainly over the next couple of days. Great, so I'm now going to turn over to our first speaker, who is Mary Rachel McCabe, who is a barrister here at Doughty Street. She principally works on community care issues, housing issues, and also court of protection cases. She has a particular interest on the rights of children and has done quite a lot of work around children in this very particular situation, i.e. children who are being placed by local authorities in unregulated or in unregistered accommodation. So without further ado, I'm going to hand over the metaphorical mic to Mary Rachel.
Thank you, Jamie. And bear with us on the tech today. I'm just sharing my screen. And welcome everyone. Thanks very much for joining us this afternoon. So as Jamie has indicated, today's webinar is about unregulated accommodation. I'm going to kick off talking about unregulated accommodation for children in care or looked after children. So that's under section 22C6D of the Children Act. I'm also going to talk about unregistered accommodation and the difference between the two and when this may be illegal. And then Just for Kids Law speakers are going to speak about homeless children and unregulated accommodation under section 17, section 20 and part 7 of the Housing Act and the particular problems that they encounter. So to kick off, I just wanted to set the scene. And so first of all, what is unregulated accommodation really? What are we talking about when we use that term? It is really supported living or semi-independent accommodation. It's usually for 16 and 17-year-olds who are in the care of the local authority. It's often just a house on a residential street, and children are visited there and they do get some support from staff as they move towards independence, but it's not quite the same as a care home with full-time staff there who are properly trained. Crucially, unregulated accommodation is not regulated by Ofsted, so it's not registered, they don't have regular inspections. And so it's really just for local authorities as corporate parents to make sure any placements in unregulated accommodation are safe and are suitable for any particular child to live in. So the first thing to say really is that not all children who are placed in unregulated accommodation will have a negative experience. Many of the placements are well run and the children are appropriately placed there after a proper decision taken in their best interests. And they can be a useful transition for 16 and 17-year-olds as they move towards independence. However, and it is a big however, unfortunately, as Jamie mentioned, unregulated accommodation has recently hit the headlines. And in particular, as you'll see on the screen there were, Newsnight did quite a lengthy investigation into them last year. All of the Newsnight episodes are on YouTube and they make for bleak viewing, if I may say. They paint what is really quite a disturbing picture of what was described in the program as a twilight world. And the reason they've become so controversial, I suppose, is that there's been a 70% increase in the use of unregulated accommodation for children in care by local authorities in the last decade. The investigation found that there's a huge variety in quality of these placements. And in many situations, vulnerable teenagers are housed with adults, some of whom have convictions for violent offences. And the evidence shows really that without the proper support in these unregulated placements, these children are at increased risks of exploitation, exposure to grooming with drugs and alcohol. There was evidence in the Newsnight programs that these premises that are used to house these children are often well known to organised criminals, and they use them as a recruitment ground. There are lots of unaccompanied asylum-seeking children who are, of course, particularly vulnerable, placed in these unregulated placements. And the police have expressed concerns about the sheer frequency of children in unregulated placements going missing. So it is essentially often cheap and poorly managed accommodation set up by private providers to make a profit. And in the Newsnight, there's quite a shocking placement where one local authority in London was paying £28,000 a month to a private company to place one child in this particular placement. So that's the context. Sorry, it's rather bleak. I'm going to move on now to talk about the legal framework and how it is that local authorities come to place children in these unregulated placements and the lawfulness of doing so. So the starting point is Section 22A of the Children Act, and this is for, again, as a reminder, children in care, i.e. children who are already looked after by the local authority, either under a care order or because they've been accommodated under Section 20 for more than 24 hours. Section 22A says that when a child's in the care of a local authority, it's their duty to provide the child with accommodation. So the next relevant section then is Section 22C. That sets out ways in which looked after children are to be accommodated and maintained. So Section 22C really sets out a sort of hierarchy of placements. This section applies where local authority is looking after a child, and the starting point is really that a local authority should place a child, well, must place a child, if possible, with a parent or with someone with parental responsibility, but that's subject to subsection 4. And subsection 4 says that the local authority doesn't have to place the child with a parent or someone with parental responsibility if that wouldn't be consistent with the child's welfare or it wouldn't be reasonably practicable. But the starting point is always a parent or someone with parental responsibility. But failing that, then subsection 5, the local authority should look to the most appropriate placement that's available. Section 22C then goes on to define what a placement means. Again, there's sort of a hierarchy there, starting with A, with a relative or friend, person connected to the child, who's also a local authority foster carer. Subsection B, a foster carer. C is a children's home. And then subsection D is the relevant section that we're concerned with today. That is a placement in accordance with other arrangements which comply with any regulations. So therein, the other arrangements section, that is unregulated accommodation. So before placing a child in unregulated accommodation, the local authority must take a number of steps. And so those are set out in part in section 22C7. So in determining the most appropriate placement, the local authority must, subject to other provisions, give preference to a placement falling within paragraph A of subsection 6. So again, paragraph A from the previous slide was family members. So again, you're looking at the priority being with family members or people who are known to the child, and then thereafter, the most appropriate placement. The local authority should also comply insofar as reasonably practicable with the requirements in subsection 8 and subsection 9, which I will come on to. So these are sort of the list of things, that the checklist that the local authority must go through in theory before they place a child in these unregulated placements. So the local authority must, insofar as is reasonably practicable, ensure that the placement allows the child to live near the child's family home, doesn't disrupt education or training, and if the child has a sibling, that it enables the child and the sibling to live together, and if the child is disabled, that it's suitable to meet the child's needs. And subsection 9 is that it should be provided within the local authority's area. Now, just a reminder that 22C subsection 7 on the previous slide said that the local authority must comply with these subsections insofar as is reasonably practicable. Section 22D, and just a reminder that you will get these slides, so don't worry about taking extensive notes. Section 22D says that the local authority should review a child's case before making arrangements to accommodate a child in other arrangements. So where the local authority is considering moving a child from a different placement, a foster placement or a children's home, to one that involves making other arrangements under 22C 6D, they cannot do so unless there's been a statutory review of the child's case. However, they can place the child without carrying out a statutory review if it's necessary for child protection reasons, i.e. to safeguard the child's welfare as set out there in subsection 2, and the placement is needed as a matter of urgency. So in other words, where a placement breaks down, and this is how children often end up in unregulated accommodation, if their previous placement has broken down and they need an emergency new placement, they are placed in unregulated accommodation without there having been a review, because it was a matter of urgency under subsection 2. So there's some further detail there set out in care planning, placement and case review regulation. Authority must take into account before placing a child in this unregulated accommodation. So first of all, under subsection A, they must be satisfied that the accommodation is suitable for the child, having regard to the matters set out in Schedule 6. And unless it's not reasonably practicable, they should arrange for the child to visit the accommodation, and they should inform the independent reviewing officer before placing the child in the unregulated accommodation. I've included there Schedule 6, which is all the matters to be considered by a local authority before they place a child in an unregulated setting. So paragraph 1 sets out the considerations in respect of the accommodation itself, facilities, state of repair, the safety, the location. And then paragraph 2, they should also take into account the child's views about the accommodation and their understanding of their rights and responsibilities in relation to the accommodation, understanding of funding arrangements. However, sadly, as I indicated at the beginning, the evidence from Newsnight and indeed in the government's own recent consultation, which I will come to later in this presentation, these placements are often unsafe. They are often in a state of disrepair. They are in dangerous locations in the sense that they are known to local organised criminals. They're lacking in proper support from properly trained staff, and they have poor facilities. So some of the reports on Newsnight included children entering these premises and they're not having a bed, just a mattress on the floor, not having sheets, not having proper facilities for cooking. So just to summarize then, I've included all the statutory provisions, and I recognize that there are a lot of them. But the summary is really that local authorities have a power to accommodate children in care in these unregulated settings, pursuant to 22C6D of the Children Act, providing, in summary, no placement with a family member is available. They comply with certain requirements insofar as reasonably practicable. And again, that includes that the placement doesn't disrupt the child's education, so it wouldn't be too far from the school, for example, and that it's within the local authority's area. Again, they must review the child's case before placing them in the unregulated placement, unless the move is necessary for child protection reasons and it's urgent. So the Friday night breakdown in placement, need for an urgent move, that can happen without a review of the child's case effectively. And I think the evidence is really that that's how a lot of these children are ending up in these placements, but then they end up staying there in the longer term. And also that the placement's suitable, and that's pursuant to the regulations that I've set out. So briefly then, the difference between unregulated and unregistered accommodation. So this is it in a nutshell. And that those paragraphs are cut and paste from a blog written by the head of Ofsted, and I've included the link on the slide because it is quite a useful blog just to set out the difference in the two types of accommodation in summary, and it helps to get your head around it. But really, as I've said, unregulated provision is allowed. It's generally 16 plus units, supported living units, or semi-independent accommodation. They provide support to children, not care. Whereas if the accommodation meets the definition of a children's home, it must be registered with Ofsted, and the failure to do so is illegal. That's it in a nutshell. I'm going to just briefly run through the statutory framework which backs that up, just so that you have it. So it's the Care Standards Act, is the relevant statute. It sets out under section 1(2) the definition of a children's home. And so an establishment is a children's home if it provides care and accommodation wholly or mainly for children. However, there's no definition of care anywhere in the legislation. And that is seen by some as a loophole for private providers to exploit and operate as unregulated provision when really they should be registered with Ofsted. I've just set out there section 5 so that you have it, which just confirms that the registration authority is Ofsted and that all children's homes in England must be registered with Ofsted. And section 11 there confirms that the failure to register the children's home with Ofsted is a criminal offence, and that would be, the offence would be committed by the manager of the home for failing to register it as a children's home. So again, there's a summary of what unregistered accommodation is. So if accommodation meets the definition of a children's home, it must be registered with Ofsted, otherwise criminal offence. And so these unregulated placements, these 16 to 7-year-old supported living semi-independent units, they are allowed to operate as they are, providing that they don't meet the definition of a children's home. If they do meet that definition, i.e. if they're providing care and accommodation wholly or mainly for children, then they must be registered with Ofsted. So I think it's a generous interpretation of these unregistered providers, and there are unregistered providers who are acting illegally, is that the management may not realize that they need to be registered. For example, if a supported living provider extends what they do into providing care without quite realizing that, they've crossed the line into becoming a children's home. They may not have realized they needed to register, but it's clear from the Newsnight report and from other media reports on this that some providers are simply willfully not registering and therefore acting unlawfully. And just briefly, I wanted to mention a case that Jamie and I worked on last year as a sort of case study. So our client was age 17 and he'd been placed in an unregulated 16+ unit by his local authority. And that was authorised in the inherent jurisdiction of the High Court. He wasn't, in fact, deprived of his liberties. He had quite high level needs. And his children's guardian in the family court was concerned about the placement being unregulated. She'd seen reports in the news about unregulated accommodation, and she queried whether the very fact of him being placed there was in and of itself unlawful. So Jamie and I looked at the documents, and it was clear from the documents that the unit he had been placed in was providing care and accommodation to him, to our client, and he was 17. So he was a child, obviously. But the unit was only a 2-bed placement, and the second bedroom, the second resident, was an adult. He was an 18-year-old. So in those circumstances, our view was that the unit didn't meet that definition of providing care and accommodation wholly or mainly for children. So the unit wasn't in fact breaking the law by not being registered, was our view. But it just shows you how there are these loopholes and how there is this opportunity for providers to exploit the loopholes. Very briefly, because I see the time, just to mention that the Department for Education recently carried out a consultation on this issue. So it was, they started the consultation in February and closed it in June. And as part of their consultation, they published this research, and I've provided the link in the slide. And the key findings of the research included that the majority of children in these unregulated placements are 16+, but there are a small number who are aged under 16, which is of course particularly concerning because they're being placed with adults and much older teenagers. The local authorities who responded in the research also reported a clear distinction between planned and unplanned placements. So they said really that planned placements they've commissioned on the basis of the needs of individual children, and the local authorities have strong quality assurance regimes in place, whereas unplanned emergency placements, they're often spot purchased and tend to have fewer quality assurance checks in place. The key findings also included that the quality of the provision was highly variable, and indeed that there was a misunderstanding amongst many local authorities as to what provision constitutes care and should therefore be registered, and that this can inadvertently lead to providers operating unregistered provisions. So there was evidence in the government's research that in fact lots of local authorities don't understand the difference between unregulated and unregistered, which is a problem. So in the consultation, the government proposed a number of reforms. The key ones are banning the use of these placements for under 16s, but no mention of banning them per se. Introducing national quality standards, so in other words, regulating them in some way, and they did set out some proposals for regulating them. And amending the legislation to clarify that distinction between unregulated and unregistered, and also increasing Ofsted's powers to take action against illegal providers. So that's the consultation in a nutshell. Mital and Katie are going to speak a bit more about that, and hopefully we can have some discussion about that at the end also.
Thank you very much, Mary Rachel. That was an incredibly clear and comprehensive account of the legal framework and the essence of the problem. I'm now going to hand over to Mital, who I think is going to introduce Just for Kids Law's report, and as Mary Rachel says, also make some observations about the consultation and the government's research. So Matau, over to you. Matau, have you got your video on, or are you still muted perhaps?
I am here. Can you hear me?
We can hear you.
Sorry, I lost complete control of my computer and cannot for some reason see the Zoom screen. I'm really sorry about this. I don't know what's happened.
I have passed control over to you. Sorry, bear with us here.
I'm really sorry about this.
I've passed control over again, Matau. It says you're now controlling my screen. So you should be able to click through the slides.
Here you go. Sorry, the whole Zoom just went. I don't know why, but hopefully it'll be fine now. Thank you. Sorry about that. So I'm going to provide a slight overview of the law. I'm sorry about the background noise. I'm conscious that most people here will probably be aware of the law, so it will just be very brief. And just to give a bit of context as to the issues that we're seeing in the work that we do, which is fed into the report that's been written. So I'm sure you're all familiar with Section 17 of the Children Act, and that it states that that a child is considered a child in need if he is or she is unlikely to achieve or maintain or have the opportunity of achieving or maintaining a reasonable standard of health or development without the provision of services from the local authority, or that their health or development is likely to be significantly impaired without such services, or if that child is disabled. The local authority has a duty to children in need within their area to safeguard and promote their welfare, and to promote the upbringing of those children with their families, insofar as that being consistent with safeguarding and promoting their welfare. And they should do that by providing a range and level of services appropriate to those children, to those children's needs. I've set out to just briefly kind of the working together guidance and link to that so that you can look at what it says in terms of assessing a child's needs, and point out that obviously there is no exhaustive list of what a local authority should provide. It should really be there. The support that's provided should be there to meet that child's needs, but there are some examples of things that we can quite often see. And that can include obviously accommodation, normally as a whole family, financial support with their education, health, etc. Section 20 states that every local authority should provide accommodation for any child in their area who appears to require accommodation, because there is no person who has parental responsibility for that child being lost or abandoned, or the person who normally cares for that child being prevented from providing him or her with suitable accommodation or care. And the latter is what we normally see in the work that we do with the young people that we support. I'm sure you've all heard of GB Southwark. I've just set out, as you're aware, it kind of sets out a series of questions that establishes if Section 20 applies. I won't go into detail those questions, but as you know, it's the applicant needs to be a child in need within the local authority's area who appears to the local authority to require accommodation. And that's for the same reasons as I've already said, that there's no person with parental responsibility for that child being lost or abandoned, or the person who's normally been caring for that child prevented from providing him or her with suitable accommodation or care. And the local authority should look at the child's wishes and feelings and consider what significance should be given to those wishes and feelings. And the law is that if that criteria is met, there is an automatic duty to provide accommodation under Section 20 to that child. And we'll look at there are two reasons set out in statutory guidance as to why that wouldn't be provided. But the general rule is that if that test is met, then Section 20 applies. What we see in our work and the young people that come to us is that quite often at the point where young people are approaching the local authority, and whether that be the housing department or children's services, they are gate kept, and obviously we only ever get the bad cases where young people aren't being supported. So there are local authorities that I'm sure are definitely doing and following the law. But the cases we see is they come into the local authority, whether they approach housing or children's services, and they are gate kept. They are we've had young people inform us that they've been told to choose between foster care or independence, or told that they can only have accommodation under Section 17 and are only treated as a child in need because they have no other need besides accommodation, and therefore do not need to be a looked after child. And there are various other reasons. So it's just to give an idea of what children and young people are facing that we interact with, and what's fed into the work that we've done. And obviously where a child is looked after, because if that child wants to be looked after, they would be provided with a heap of support, including accommodation, of course, including financial support, visits from a social worker, support with their education, and obviously it goes on. And what also they will be provided with is leaving care support if they meet the 13-week, if they are looked after for 13 weeks before they turn 18, and that means that they will get ongoing support whilst they're transitioning into adulthood. That will be up to 25 if that young person wants it, up until 25. And that will include things like having a personal advisor, someone to support them in their day-to-day life, a pathway plan setting out what their needs are and what support they're going to receive, assistance with their employment, educational training, help with their living costs, including a leaving care grant, a higher education bursary, and basically the law says that assistance to the extent their welfare requires it. Sorry, I skipped a slide, so I'm going to go back. Decided that it was in the wrong order. There's also a really helpful a statutory guidance called the Prevention of Homelessness and Provision of Accommodation for 16 and 17-year-old young people who may be homeless and or require accommodation. It's a really catchy title, but it is a really helpful guidance. I won't go into it in any detail, but it just provides details to both children's services and housing services as to what they should be doing if young people are approaching them for accommodation. Sorry, I don't know what's... Mary Rachel, have you taken over my screen again? So the guidance is really helpful, and it's something that I would definitely recommend going to if you are supporting a 16 or 17-year-old. I have lost control of my screen. Sorry, a technical issue. Or the screen. Okay. All right, sorry, thank you, I think it's back. And so what that guidance also says, it has some really helpful provisions in it, but one of the things it also sets out is when the local authority can, or it doesn't have to provide Section 20 accommodation. There are only two situations in which the guidance, in which they can do that, and that's set out as the child or the young person not being a child in need. Now, I can't really envisage, or never come across a case where a homeless young person or a 16, 17-year-old is not a child in need. Or where a 16 or 17-year-old who's been properly and fully advised of the implications of being accommodated by the housing department or children's services and having the capacity to reach that decision has decided they don't want to be looked after under Section 20 of the Children Act. Otherwise, if they meet that criteria set out in GB Southwark, that young person should be accommodated under Section 20. So just as a brief overview, if a child is accommodated under Section 20 of the Children Act, they will be looked after by the local authority. They'd be provided with support while they are a child. When they turn 18, if they've met the criteria, they will be a former relevant child and supported until they're 25, or until they're 21 and 25 if they want to be supported. And during that period, as a care leaver, the local authority acts as a safety net, and while they're transitioning into adulthood. So if something goes wrong, for example, if they're evicted or they become intentionally homeless, the local authority will have a duty to safeguard their welfare. And what we find sometimes is, as I mentioned before, that some young people are at 16, 17 approaching the local authority and being offered Section 17, accommodation under Section 17, or accommodation under the housing route. And the problems with that, or in particular with Section 17, is that though that child may be looked after, they wouldn't have, that child may be provided with accommodation, they wouldn't have the support that they would receive if they were a looked after child while they're still a child. But they equally will not continue to have that support as a care leaver, and therefore they'll lose that safety net. And again, that same thing applies if they are accommodated under the Housing Act. Once the housing department has discharged their duty, if they were to then become evicted, or something else was to go wrong, or they needed support beyond their accommodation, that support will not be provided because they are not a looked after child or a care leaver. An example, I'm sorry, the slide has messed up a little bit, is of a young person, Megan, obviously we've changed her name, who we supported retrospectively. Megan became homeless because her mum died, and she was staying with her stepfather, and that relationship broke down completely. And she had absolutely no relationship with her stepfather, her biological father, because of the abuse she and her mother had suffered from him. When she was a child, she approached the local authority at 16. She did that on several occasions and was told that there was no accommodation available to her. And during that time, and this happens quite often to the young people that we support, she spent the night in open spaces. The places are open for 24 hours. She in particular stayed in places like McDonald's, casinos and hotel receptions, but worked with young people who ended up sleeping in a stairwell, have gone to A&E, or just anywhere, even a police station, just so that they could be safe throughout the night because they had nowhere to stay. Eventually the local authority did place her, give her some accommodation in an unregulated placement, but she was asked to leave after 2 weeks because she breached the rules of that accommodation by allowing one of her friends, who was also a child, into the accommodation. She was homeless again and safe assessed until again she was eventually given a hostel in another unregulated placement where she stayed for 6 months. During that time she received no support besides food vouchers. She had no financial support and came into financial difficulties and got involved in criminal activities. During this time, no assessment of her needs was done by social services. No one provided her with information as to the difference of being accommodated under the by children's services or the housing department. She was basically not told anything and just took whatever she could get. When she turned 18, she was told by social services that her case was going to be closed despite her wanting and needing more support. And then eventually she was evicted from her accommodation and became homeless again. Luckily, she was referred to us, and we argued that when she first approached the local authority, they should have assessed her needs, and they failed to do that and actually accommodated her under Section 20 because we felt that she met that criteria at the time. We argued that she should now be provided with leave and care support as a former relevant child. Though the local authority initially refused to do that, eventually, with the threat of judicial review, they agreed to provide her with leave and care support as a former relevant child, which has transformed her life. So that's the end of my slides. Thank you.
Thank you very much, Vital. That was excellent and a very comprehensive overview. I mean, if I've understood one aspect of your presentation correctly, whilst for children who are in care, there are certain restrictions on children being placed in unregulated accommodation, restrictions that Mary Rachel has already pointed out can be avoided in urgent cases. If you simply don't put the child in care at all in the first place and divert them towards Section 17 accommodation or indeed homelessness accommodation, then you can put them in unregulated accommodation without any restrictions at all. So it's another sort of huge lacuna, or one might say hole in the legislation. So it's very interesting. Thank you very much. So our last speaker this afternoon is Katie. I believe Katie also has some slides. I'm hoping, Katie, you can access those slides and your video cam easily enough.
Yes, I think so. They seem to be okay so far.
Fantastic, thank you. Well, over to you, Katie.
Great, thanks, Jamie. I'm a policy officer on housing and social care at Just for Kids Law, and I'm going to talk about some research that we did recently on homeless under 18s and unregulated accommodation. So just to give some background, first of all, as to why we decided to look at this issue. As Mittal has outlined already, this is really quite a long-standing and frequent issue that we see in our both our legal and advocacy casework, in terms of homeless children, usually aged 16 or 17, approaching the local authority and not receiving Section 20 status, as we believe they should. And we knew from talking to other organisations working with children and young people that we weren't the only ones seeing this. And that sort of led us to suspect that it was a fairly widespread and systematic issue, rather than something that we were seeing just ourselves. Also, as we're London-based, we wanted to find out the scale of the issue nationally. And we also wanted to feed this issue in light of the unregulated consultation, given that that only refers to children in care. So on the consultation, Mary Rachel's already given a really comprehensive overview, but just to highlight really that in the research that DFE commissioned that sits alongside the consultation itself, they looked at the numbers of looked after children in independent or semi-independent placements, and they came up with a figure of 6,180 looked after children who were in these settings at 31st of March 2019. But their research didn't look at those children in unregulated settings who are not in care. And the proposals that they're putting forward, so the ban for under 16s, the various different options for regulation, won't directly impact children in unregulated settings who aren't in care. So that's something that we just really wanted to highlight in this work. So what did we do? We sent freedom of information requests to all English local authorities, of which there are 343, and we asked them three things. We asked them how many 16 and 17-year-olds they had housed in the last 2 years under Section 17 and Part 7 of the Housing Act. And we asked how many in those categories, so Section 17 and Part 7, they'd housed in unregulated settings. And we also asked them to share their joint protocol on homeless 16 and 17-year-olds, which they're required by statutory guidance to have. We got replies from 39% of local authorities. And based on, oops, my turn for slide issues. So based on the information they provided, in relation to our first question, around how many children they'd housed outside of Section 20, we estimate that in 2018 to 19, local authorities accommodated 2,585 16 and 17-year-olds without making them looked after children. 41% of those under Part 7 and 59% under Section 17. And that represents a small increase on the previous year. So this is how the data breaks down. So you can see that in 2018 to 19, so these are the actual figures, local authorities told us that they housed 592 children under Section 17, 418 under Part 7. That gives a total of 1,010. And we estimate that across all local authorities, that would be 2,585 children. Moving on to our second question, we asked local authorities to provide figures for children in unregulated settings who are not in care. And based on the data they provided to us, we estimate that at 31st of March 2019, 1,498 16 and 17-year-olds who were not looked after were housed in unregulated settings. And again, that's a small increase on the previous year. You might have noticed that the date format for this question is different to the previous one. And that's because in this question, we wanted to make sure our data was comparable with what DFE collected in their research. So the 6,000 figure they arrived at, and they did that looking at the specific date of 31st of March 2019 and for several years previously. So that's why we asked our question in the same format. I suspect if we'd asked over the year, we might have got a much higher figure. So we can reasonably assume that this is quite a conservative estimate. And this is how the data breaks down. So you can see at 31st of March 2019, local authorities told us they were housing 357 children in unregulated settings under Section 17, 228 under Part 7, giving a total of 585, and across all local authorities that would be 1,498. So just to very briefly recap and summarise those findings again, we found that around 2,500 children aged 16 or 17 are accommodated each year by local authorities without becoming looked after, and around 1,500 children aged 16 or 17 who are not looked after are housed in unregulated settings at any one time. And if we combine that figure with the DFE's total of 6,000, that means that around 1 in 5 children who are housed in unregulated accommodation are not in care. So why does this matter? I won't go over this in any detail because Mittal has already done such a comprehensive summary. But as Mittal said, a child who is not housed under Section 17 will receive a much lower level of support, both prior to becoming 18, and that's particularly concerning in light of the minimal support that is provided in some unregulated settings. So for example, where there's minimal staff contact hours, without the oversight of a social worker looking out for that young person, that could lead to quite a concerning situation, which can leave children at risk. And that situation just continues after they turn 18, if the young person doesn't then get care leaver status and won't be entitled to all of the support that goes with that. And what we wanted to highlight in our report really is just the parallel system that has developed, in that, in our experience at least, what are children with very similar case histories, similar support needs are receiving different entitlements, and that the decision-making process can often seem quite arbitrary and a postcode lottery depending on what local authority the young person is based in, as to who gets Section 20 and who doesn't. And that can then lead to a situation in which the same setting can be housing children under Section 17, under Section 20 and under Part 7 who are all receiving different entitlements. In our report, we also talk about a loophole, and this arises from the fact that, as Mittal has already explained, local authorities can accommodate a child without making them looked after if this is what the child decides. But as the statutory guidance states, the local authority must be satisfied that the young person's decision is properly informed and has been reached after careful consideration of all the relevant information. And instead, what we see are examples of local authorities persuading young people to go down the Housing Act route. And we can only assume that that's because it's a much cheaper option for local authorities, both in the long and short term. So Mittal's already mentioned some of these, but these are things which local authorities have said to young people we work with. So things like, if you become looked after, this will involve frequent visits from social workers. Under Section 20, the only accommodation available is foster care. Section 20 accommodation isn't available for you because you're 17 and a half. A young person being asked whether they want to be in foster care or be independent, or as though that's the binary choice and those are the only two options. And another young person being told, you're independent, the only support you need is with your accommodation. So implying that they don't need any other support despite being a child, and needless to say, those are all incorrect. So what needs to change? In our report, we set out a series of recommendations to government and to local authorities. So just to pull out the key ones briefly here. So we're calling for government to ensure that no child under 18 is placed in unregulated accommodation, regardless of which piece of legislation they're being housed under. And so the flip side of that is that we're calling for all settings housing under 18s, regardless of which legislation they're housed under, should be regulated and inspected by Ofsted. We also believe that children should be provided with independent advocacy about their housing options to help them make the decision that's right for them. This is actually something that's set out in the statutory guidance already. So we're calling for additional resources for local authorities to fulfil this and other existing statutory duties. And although we would recognise that the statutory joint guidance on this issue is very good, there are some changes that we're asking to be made to it. So firstly, to clarify that section 20 should be a default position for any homeless 16 or 17-year-old. And secondly, that a new status of vulnerable 16 or 17-year-olds should be created for those young people who do choose not to become looked after. And we would always expect there to be some, and say that their decisions should be respected. But this new status would allow more flexibility, but with the same entitlements that looked after children receive. So that's it in terms of the whistle-stop tour of our research. I'm very happy to answer any questions.
Katie, thank you very, very much. That was very interesting. One thing that occurred to me before we open up for questions is that I noticed in the government's own research that they said one of the reasons why it seems local authorities were having to send some children, particularly children with high-level needs, to unregulated accommodation is because regulated accommodation or registered accommodation providers were wary of taking on difficult cases in case it undermined their Ofsted ratings. In other words, if they couldn't demonstrate that they were capable of looking after the most vulnerable children, then that might affect their business model. And so I just wonder how this interaction between regulation and under your recommendations, increased regulation, and the sort of commercial concerns of these operators might be better managed so that they didn't make those types of judgments which one might expect to put local authorities in difficult positions. Anyway, those were three really fascinating talks coming from different perspectives. We have some questions and some observations. In terms of observations, Ed Nixon has made a number of very helpful ones. The first one he's pointed out, which I'm sure many people will know, is that even the restrictions on the exercise of the power to place children in unregulated accommodation have currently being well, temporarily, we don't know if it's temporary, but it's currently temporary. They have been suspended by statutory instrument 445, which is a now notorious statutory instrument implemented by the government, which has relaxed, if not done away with, a whole host of protections within the Children Act and the associated regulations, purportedly under the guise of COVID-19, but there's a great deal of suspicion that in fact a lot of these reforms are ones that the government would like to see in place on a permanent basis. And so Ed has just very usefully reminded everybody of that fact. He also says that he's recommended that the Annex A of Ofsted's introduction to children's homes is a very simple and helpful tool in determining the differences between a children's home and supported accommodation, which of course doesn't have to be registered. Viv Parker's asked a question which I thought perhaps Mary Rachel you might be able to answer. She says this: what if a 16-year-old subject to a care order in a flat with staff 24/7, subject to a dole's, only child in the flat? Is that a children's home?
I don't think so. If it's the only child living there, I wouldn't say that is. I think that's an interesting question and not one I've ever given thought to. If the child is completely on their own, I mean, is it an accommodation that's providing care and accommodation wholly or mainly for children? Does it meet that definition? I mean, if it's one child, I'm not sure it does really. I don't know. Do you have thoughts on that, Jamie? That's well,
I just wonder if it's one child only, then it's wholly, isn't it? I mean,
yeah, well, that is true, but wholly or mainly for a child. But a children's home for one child, that sounds curious to me.
Well, perhaps the point of all of this is some pretty curious arrangements are being set up all over the place because there's money to be made and the regulations can be avoided one way or the other.
Yeah, and the point you made about there are obvious concerns about introducing regulation into the sector, and I've read quite a lot of NGOs' responses to the consultation, children's rights NGOs, and that is a repeated concern that if obviously most children's rights NGOs welcome increased regulation, but there is the obvious fear that introducing regulation will drive providers out of the market, for one, so that there are even fewer placements for these children. And two, as you say, the providers are often then chasing the top Ofsted rating, which, as you said, they're less likely to take the most complex or difficult children. But the Howard League responded to that in their consultation response just by simply saying that cannot be the reason why the government fails to protect our most vulnerable children, and there must be a proper mechanism for enforcing national standards, and that the government just has to tackle these issues. You know, that's not an excuse not to introduce some form of regulation, even if it's slightly more light touch regulation than standard sort of Ofsted regulation. But it's right that these private providers have a lot of power at the moment, and local authorities are sort of weak in the face of that power because they need the placements for the children, and so they have to pay the money for these low quality placements. It is a really tricky issue.
Yes, I mean, I think there are perhaps a suggestion that there's some other areas of public life where privatisation has created similarly perverse incentives. And anyway, that's discussion for another seminar.
Yeah.
There are some other questions here. An anonymous attendee has said, with care not being defined under the CSA Act, what guidance is there about what care constitutes and where is the line to be drawn? Katie, do you feel like you want to answer that? I think I think we've lost Mittal, unfortunately.
I think she's there. I think we had lost.
I'm sorry. Mittal, are you there? Oh, there you are. Well, Mittal, I was actually going to suggest another question for you, which has been asked by Tom Huxma, who says this: is it common for the success of a former relevant child, or is it common for former relevant child status to be backdated for these young adults that have not been supported by Section 20 when they ought to have been, which is, I think, similar to the case example that you gave, and is a frequent problem. So how successful are Just for Kids for Law in trying to obtain retrospective status as a former relevant child?
Yeah, I mean, it is quite common. I mean, it's a lot of our casework is retrospective cases where young people have come to us after they are adults and have become aware of the fact that they might have been entitled to support from children's services when they were 16 or 17 years old. And I would say almost all of our cases, bar a few, are successful. The more recent case law doesn't provide for the child to get all of the services a former relevant child would get. There is some discretion for the local authority, but they would be able to get the status of the former relevant child and have services provided to them.
Great. Mary Rachel or Katie, did you have anything further to add about guidance for what the meaning of care is?
I don't know it off the top of my head, but I know there is some sort of guidance in regulations about care standards. It doesn't actually define care, but I'm sorry, I can't be more helpful than that. I'm happy to respond, follow up in writing on that particular question, unless Katie has any other thoughts.
So no, it's not an area where we have particular expertise ourselves at Just for Kids Law, but I would just draw attention to the brilliant work of the Keep Caring for Children to 18 campaign. I don't know if people will have come across this, being led by Article 39. So they've put forward a proposal for the children's homes regulations to be modified so that they would apply or be able to be applied to settings housing children up to 18. And I understand that there is some more detail in there about what the difference between care and support is. So happy to share some more information on that later if that's useful.
Thank you, Katie. Yeah, it's interesting because care and support are obviously both terms that are used under the Care Act 2014, which is concerned with the provision of care and support to adults. And nobody's ever deemed it possible to define the meaning of care under that legislation, or indeed support. It's intentionally incredibly wide. So it's quite difficult to see how one could ever come to a fixed meaning, which would then help with this process of distinguishing between registered and unregistered placements.
Yeah,
I'm going to ask you all one question at the end, which is effectively this: what would be your principal suggestion in terms of reform? It's a question which a number of attendees have asked in one form or another, and I'm going to look for a snappy answer to that in light of the time that's available. And feel free to adopt something that's already been suggested by the government or indeed by Just for Kids Law, but I just want one. In the meantime, there are just another couple of very quick observations and questions people have asked. First is Rob Ratton says, how would you recommend that allegations against staff should be managed in unregulated settings? And if I understand Rob's suggestion correctly, I think what he might be saying is, from a legal perspective, what can we do in an unregistered or unregulated setting to try and achieve better outcomes for our clients if there are indeed things going wrong in the placement, if, for example, there are allegations that staff haven't been providing proper professional care or something of that nature. Mary Rachel, do you think that might feed into a possible application for judicial review, or how would you see that type of issue being resolved?
Yeah, it could do. It's obviously something that the child, if it's a child in care with an independent reviewing officer or social worker, it's something they should be reporting to their local authority. Because then but I think it could go out to the suitability of the placement in any judicial review. Mm-hmm. Very tricky allegations against staff. Ultimately, it's for their employer to resolve, really. But it's certainly an issue that has been raised all through the Newsnight programs. These unregulated providers aren't training their staff properly. And because they're not regulated or inspected, they're not doing anything about it because there's nothing to bite them, nothing to punish them. So I think, yeah, it could possibly feed into a judicial review, but on a practical level, I think very difficult, other than telling the child to report it to their social worker or IRO and hope that something is done and that they're moved, or that something's done about that placement. But again, without regulation, I think all roads lead back to some form of regulation, in my view.
Okay, well, on that note then, I'm going to pass this final question to you all to see whether or not you've got a magic solution in a few words as to what you think would make the biggest change, keeping in mind, for example, the tensions we've heard that might exist if you do over-regulate versus the problems of leaving it up to children to raise their concerns when they're already vulnerable and have been placed in situations that they ought not to have been. So I'm going to start with Mital. Do you have in your own minds a sort of single idea you think would make the biggest difference?
I don't think there is just a single idea that would make a difference, but I think going back to the changes we've called for that Katie went through, I think ensuring that no child is under 18 is placed in unregulated accommodation, regardless of which piece of legislation their accommodation under, would be the change I would be calling for.
Interesting. Okay. I've just got in mind what Mary Rachel said at the beginning of her presentation, that in fact quite a lot of people are in unregulated accommodation and it works very well for them. But you would suggest perhaps that we take the cautious route and just regulate all placements. Very interesting. Katie, what do you think?
I think, so the one thing I think that would make the biggest difference at the moment is just for the needs of the children that we've identified not to be sort of missed out in the current proposals being put forward by DFE, and for DFE to take some ownership and accountability for those children, given that Children's Services has a primary duty to these group of children, and assessments, you know, are taking place under Section 17. To me, all of that kind of points to these being the responsibility of DfE, and we do recognise the sort of unintended consequences of regulation, particularly in relation to this group. So as has been mentioned, you know, could lead to providers going out of the market, hopefully some of the worst ones, but nevertheless that could lead to a dip in supply, and children who are housed under the Housing Act or Section 17 could then be pushed potentially into other areas which would be worse options for them, like temporary accommodation. But you know, as I think everyone else has said, kind of on balance, that can't be a reason not to regulate. So we just call for the needs of those children that we've identified to be thought about and taken into account as part of any future plans.
Thank you very much. Mary Rachel, anything snappy to add at the end about what you've done?
Yes, I would ask that central government invests properly in local authorities' children's services and gives them a massive pot of money so that they can create and grow their own services and accommodation for children that is run by the local authority locally. And I know we need a magic money tree for that, but we've kind of got one at the moment, so that would be my ask.
Well, great. Why tinker when you can have radical reform? I did put it as an open wish list, so it's good of you to be direct about what you think ought to change. Just thank you all very much. Mittal, Katie in particular, thank you very much for taking your time to join our seminar this afternoon. It's been incredibly insightful to hear you talk about these problems that you've obviously done so much work upon, and best of luck carrying on that work. Mary Rachel too, thanks for a very clear and useful summary of the law and insightful analysis of the problem. If I can just thank you on behalf of all the people who've doubtless been listening intently throughout this hour, thank you very much. Thank you all, everybody who's participated. As I said at the beginning, there will be a copy of the slides available, and indeed a video recording of this session on the Dowd Street website. Maybe not before the weekend, but if not, certainly early next week. And it just leaves me to say, enjoy the rest of your afternoon and take care. Thank you very much.
Thank you.